coming this summer. So the agenda for today, just going to give a brief overview of what we're doing here at Legal Aid and how folks can access our services, walk through some of the fundamentals of federal student loans, talk about what borrowers need to be thinking about right now with the end of repayment, discuss some time-limited options, discuss the cancellation program, some other regulatory changes that are happening, and then finish off with resources that we have for student loan borrowers and providers, and also questions and answers. If you have questions throughout, though, please go ahead and put them into the chat, and we'll do our best to address them as we're going if they're topic related, and if not, we'll get to them at the end. So here at the Legal Aid Society, we are the only law firm dedicated to providing free legal services to low-income individuals in the 5 counties in Northeast Ohio that we serve. We provide services across a range of areas, including consumer protection, employment law, family law, immigration, housing, government benefits, and some work in education as well. To be eligible for our services, an individual has to meet a number of different requirements. First, they have to be located within our service area, which is Cuyahoga, Geauga, Lorain, Lake, and Ashtabula. Their household has to be 200% or below of the federal poverty line. We have to make sure that there's no conflict of interest in representing that individual. So, for instance, we can't represent one spouse and another spouse in the same divorce matter. And then there has to be a legal solution at stake, and it's something where our expertise really comes into play. The range of services we provide include just brief advice to individuals, kind of guiding them and steering them in the right direction, all the way through full representation, full litigation of cases and so forth. We also do a lot of work out in the community, including brief advice clinics, community presentations, and so forth, where we try to reach as many folks as possible to help them with their needs. If you do want to reach out to us, there are a variety of ways to do so. So the easiest way to both get information and also to apply for our services is to do so on our website, lasclev.org. Folks can also do so over the phone. And then, as you can see, if you have specific requests for presentations or other events in the community where we could be a resource, you can go ahead and email us at outreach@lasclev.org. And then we also have for individuals in the community specific information lines where they can call and ask questions. So we have a tenant information line and an economic justice information line, which I'll talk about a little later, includes some student loan specific resources for individuals. So gonna jump right in and start with the key takeaways, which I think are the 2 most important things that you can take from this presentation, even if you ignore everything else that I say. The first is repayment. I know with the repayment of federal student loans appears like it's actually going to go back this coming summer. Since March 2020, there has been a pause on the payment of federal student loans, and there have been these continued extensions of that deadline. While it's certainly possible that it'll get extended again, I am highly doubtful that it will be. And I think everyone should be operating under the assumption that repayment is going to be starting again this summer, and borrowers should be taking steps to prepare right now for that return to repayment. The second main takeaway, which we'll also talk about more in depth in a little bit, is that for certain borrowers, there are time-limited options available right now that the Department of Education is providing. In particular, borrowers who are in default have access to a program called Fresh Start, which we'll talk about in a little bit. And then borrowers who have been in repayment for a long period of time might be eligible for what's being called the IDR Income-Driven Repayment Account Adjustment. which would essentially put them on a path closer towards loan forgiveness. And we'll talk about both of those in more depth, but suffice to say, borrowers should also be thinking right now about some of these time-limited options that are available to them. So I do want to kind of just level set, though, before we get into the specific programs and talk about some fundamentals of student loans. Who has student loans? What type of loans exists? How do borrowers figure out what types of loans they have, and who are the key players? And we'll start off with who has student loans, which is a ton of us. 45 million borrowers have close to $1.7 trillion in federal student loans. That number is going to hit 2 trillion over the next few years. And about 92% of those loans are federal student loans. About 40% of borrowers who have student loans never completed their program. So they have the debt, but they don't have a credential to show for it. And about 1 in 5 student loan borrowers were going into the payment pause in March 2020 in default on their student loans. And we'll talk about later some of the consequences for what it means to be in default. I think it's also particularly important to note that the student loan crisis has particularly negative effects on borrowers of color. Due to historic and structural racism and discrimination. There's a difference with respect to who has to take out federal student loans in the first place. There's a difference as to how much students have to borrow to attend school. And then there's a distinction in repayment. And so the reason I like to flag this is because when we're thinking about what programs exist for student loan borrowers and what programs should exist, I think it's important to keep in mind who's bearing the brunt of the student loan crisis. It's also an intergenerational problem. Nearly 9 million federal student loan borrowers are over the age of 50, and the fastest growing population of those with student loan debt are those 65 years and older. And so you can think about what that means for a borrower who's on the precipice of retiring, but faced with significant student loan debt that they either took out for themselves or for their child or grandchild. And so it's not just a young or middle-aged problem. It is a problem that impacts everybody. So if a bunch of us have student loans, what type of student loans do we have? And the first big distinction that I think it's important to make is between a private student loan and a federal student loan. So a private student loan are those that are not subsidized by the federal government. They are issued by private entities like schools or banks. They are significantly less regulated than federal loans. And they're generally governed by the specific contract between the borrower and the private lender. Most of what we're going to talk about today just applies to federal loans because the rights that exist with respect to private loans are so kind of specific to the loan that the lender has given and that the borrower has taken out. Federal loans, in contrast, are those that are funded and regulated by the federal government. Some of them are issued directly by the federal government, and some of them are actually issued by a bank or private lender, but then guaranteed by the federal government. So there are kind of 2 main federal loans then. The first being those that are directly issued by the federal government, which for the most part are called direct federal loans. And then there are those that are just guaranteed by the federal government. And those are called Family Education Loan Programs, or FFEL loans. For the most part, FEL loans are less prevalent today than direct loans, largely because since July 2010, the government is only issuing direct loans. But as we'll talk about later, for borrowers who have been in repayment for a significant period of time since before 2010, it'll be important to figure out what types of loans they have, whether they're direct or FEL, because it impacts what rights they may have. Also, I have listed here Parent Plus loans. Parent Plus loans are generally issued by the federal government themselves, but there are some specific terms and conditions that apply to those loans that differentiate them from other direct loans. So to figure out what type of loans a borrower has, the first kind of easiest way to do so is to look at the contract that the borrower has, which is called the master promissory note. And that'll show whether the loan was issued or guaranteed by the federal government, or whether it's one with a private lender. I think a lot of borrowers, myself included with respect to my student loans, don't necessarily retain those contracts from years ago. And so there are other steps to take to figure out what type of loans someone may have. The first is to pull what's called someone's NSLDS, which is essentially just an acronym for all of their federal student loan data. And to do so, a borrower can go to their federal student aid account on the Department of Education's website and navigate to information that's specific to their federal student loans, which will show all of the federal loans that they've taken and what type of federal loans those are. On our website, we, as of yesterday, now have a document in our self-help section on student loans, which specifically directs the borrower to the specific steps that they have to take in order to pull this document to see what type of loans they have. This will only show a borrower's federal loans, though. And so if you're trying to figure out if a borrower also has private student loans, the best source is usually a credit report, which on annualcreditreport.com, a borrower can pull up a free credit report 3 times a year. So who are the key players that are involved in all of this? So the first is ED, or the U.S. Department of Education. They are as the entity that controls the federal student loan system, the largest lender of federal student loans in the country. There are also private banks that either issue private loans or have issued those government loans before 2010 that are then backed up by the federal government. And then there are what are called loan servicers. And these are essentially third-party companies that collect and keep track of borrowers' payments on behalf of either the U.S. Department of Education or private banks. And so a borrower will often think that they have a private loan, or because they'll see that all of their correspondence comes from an entity like Mohila or Great Lakes or Nelnet or Navient. But more often than not, those companies are just acting as the loan servicer, and it may actually be the U.S. government as the holder of the debt. So it's important to keep that distinction between the holder of the loan, so usually for the most part the Department of Education, and the entity that's actually doing the outreach to the individual borrower. So I now want to switch over to kind of the most important topic of the day, which is the end of the COVID-19 payment pause and the financial cliff that we know is forthcoming. We don't know the exact date that the payment pause is going to come to a close. And that's because the Department of Education has tied the end of the payment pause to the cancellation litigation that's currently ongoing, and that I promise I'll get to before we finish out this program. Essentially, what the Department of Education has said is 60 days after that court case is over, or 60 days after June 30th, whichever is earlier, that's when the payment pause is going to end. As a practical matter, the Supreme Court is likely not going to rule on the cancellation case until mid to late June anyway. And so we're really looking at the payment pause ending 2 months after mid to late June. The problem is we know what happens based on historical experience after an emergency forbearance ends. So for example, after several hurricanes and wildfires, the Department of Education put a bunch of borrowers into emergency forbearances for just a limited period of time, and just a limited number of borrowers. And as those borrowers were moved back into repayment, a significant number of them just never returned to repayment, and instead their loans became delinquent, so they fell behind on their payments, or they went into default. And the fear now is that there are so many millions of borrowers who have had their loans paused for over 3 years that it's the first time that the federal government is going to be moving this many borrowers for this long of a time period back into repayment. And so there's a real significant threat that millions of borrowers can be thrust into both delinquency and then default on their student loans. And the reason why this matters is because defaulting on a federal student loan can be catastrophic for a borrower. So number one, a borrower who is in default cannot take out new federal loans and is not eligible for federal grants. Number two, the borrower is going to experience significant credit damage. There's no statute of limitations on when the government can go after a borrower who has defaulted on their federal loans. So a borrower who defaults at the beginning of 2024 could be facing penalties 10, 15, 20 years down the road. Perhaps most importantly, the government wields very significant involuntary collection tactics that can harm individuals. So for example, the government has extensive authority to offset individuals' tax refunds to pay back defaulted federal student loan debts. This can include an individual's earned income tax credit or child tax credit. And so you step back and think about that. The very same programs that are designed to lift up individuals out of poverty, the government has the power to seize that money to pay back a federal student loan, thereby depriving that individual of these benefits, which are so critical. The government can also garnish wages, up to 15% of a borrower's disposable wages. And the government can offset individuals' Social Security retirement benefits. And so when we think about older borrowers in particular, and older borrowers who rely on those retirement benefits to survive, the threat of default and the government's collection tactics after default can pose a really significant financial threat. The other reason this is really concerning is based on who was in default at the time we entered the payment pause, we know who's most likely not to learn about repayment resuming and who's most likely to default again. This includes low-income borrowers, borrowers of color, students who attended for-profit colleges, and older borrowers, those age 60 plus. So, if there's one takeaway from today, it's repayment is about to resume. Borrowers not only need to know that repayment's starting, but they need to know that they can take plans right now to get into the right repayment plan to help them avoid delinquency and default. And for most borrowers, particularly low-income borrowers, the best plan is going to be an income-driven repayment plan, or IDR. Now, before the pandemic started, a ton of borrowers who were eligible for IDR didn't know about IDR and just didn't enroll in it. One statistic I found really staggering is that 43% of borrowers who are on income-dependent government assistance, like SNAP, are enrolled in an IDR program, which means 57% of borrowers who most likely would be eligible for a $0 monthly payment on their IDR plan were not enrolled in such a program. So what is an IDR program? What is income-driven repayment? Like the name suggests, it is a repayment plan that ties an individual's monthly obligations to their income. So a certain amount of their income is protected from collections each month, and the government engages in this calculation and says, based on your income and your discretionary income, this is what we think you can pay each month. For most low-income borrowers, that payment amount could be as low as $5 to $10. And for some, it could be as low as $0 a month, which means for all of those months the borrower's enrolled in an IDR program, they don't have to pay anything, but they're not facing the consequences of default, and they're actually earning time towards forgiveness on their student loans. The entire process for applying for an IDR plan, I'll get into in a few minutes, can be pretty simple. There's an online application where a borrower can say, I just want to be in the IDR plan that gives me the lowest monthly payment each month. There's a checkbox the borrower can check. And for most borrowers, particularly lower income borrowers, that's the option that's best for them. Now, where IDR can get tricky is that there are, as of today, 4 different income-driven repayment plans. And some of the plans apply to certain types of loans, and they handle married borrowers slightly differently, and they change how long it takes for forgiveness to take, and they change how much of discretionary income is protected from repayment. I think stepping back, the most important thing is the default rule for borrowers is really just choose the option with the lowest payment plan, because 9 times out of 10, that's going to be the right plan for the specific borrower. I will, though, just very briefly go through the different IDR plans that exist, just so you know them. But as the image I have on here suggests, it is headache inducing when you get into all of these plans and the complexities that exist. So just before we go into those 4 plans, though, by way of comparison, the kind of baseline standard plans is a 10-year plan. The baseline standard is 10 years, the exact same amount over those 10 years. A graduated plan, which is usually 10 years, but can be longer, and has a set amount of payments that starts lower and grows over time. And then an extended payment plan, which isn't tied to income, is set for about 25 years and has the exact same amount over those 25 years, but doesn't fluctuate with an individual's income like an IDR plan does. So the first of the 4 IDR plans, and I'm going to go through these pretty quickly just because I don't want us to get lost in the details on these, because I don't think it's as important as just knowing that these plans exist and directing borrowers to selecting the option with the lowest payment amount. But the ICR plan is going to be particularly important for your Parent Plus borrowers, so those borrowers who have loans for their children and grandchildren. And that's because Parent Plus borrowers, in order to be eligible for an income-driven repayment plan, first need to consolidate their loans, basically combine all of their loans with the Department of Education into a new loan. And then they're only eligible for the ICR repayment plan. Under this plan, a borrower will pay about 20% of their discretionary income each month to their repayment obligations, and the loans will be canceled after 25 years in repayment. Then there's what's called the Repay plan. And there are changes that are forthcoming to the Repay plan, which is going to make this, for most borrowers, the best plan. It applies to all direct loans. And as of right now, it only requires a borrower to pay about 10% of their discretionary income each month to their loan obligation. And a borrower will get cancellation if they're in repayment for 20 years for undergraduate debt and 25 years for graduate debt. I'm going to come back to some of the changes that are coming to the Repay plan shortly. Then there's the income-based repayment plan, which can apply for both those FFEL loans, so those loans pre-2010 that were issued by banks and backed up by the federal government, along with direct loans. And the amount that a borrower pays, it hinges on when they took out their loan, but suffice to say it's between 10 and 15% of their discretionary income. And then cancellation will occur between 20 and 25 years after in repayment again, depending on when they took out their loan. And finally, there's the pay plan. This applies to direct loans. It requires a 10% payment of discretionary income, and cancellation occurs after 20 years. Each of these plans handles married borrowers slightly differently. And so if you encounter a borrower where for some reason it doesn't make sense just to choose the plan with the lowest monthly payment automatically, then I would encourage you to either check out our resources on our website or through the National Consumer Law Center on the variances between these plans as they relate to married borrowers. Now, I flagged this a minute or two ago that a modified repay plan is coming. So in February of this year, the Department of Education released a proposed rule that completely overhauls the repay plan. They haven't finalized this rule yet, and we don't know when they're going to finalize it. And it's unlikely that this new payment plan will be finalized before borrowers have to go into repayment this summer. And so I'm going to talk about these changes just so you have them in mind in the future. But I think, short term, get your borrowers into an income-driven repayment plan and have them choose the one for the time being with the lowest monthly payment amount for the most part. When this new plan is finalized, though, the government is designing it to be the best plan of all plans, so that instead of having to navigate all of these different IDR plans, a borrower will be able to say, okay, the repay plan is the way to go. And the reason that that will likely be the case is, number one, under the new repay plan, once finalized, the department has proposed reducing the amount a borrower with undergraduate debt that they have to pay to only 5% of their discretionary income. And they've also raised the amount of a borrower's income that is protected, so that it isn't even considered discretionary in the first place. For graduate students, the government will continue to charge 10% of the discretionary income under this plan. But for a borrower who has both undergraduate and graduate debt, it'll be a weighted average of the two. The biggest change, and the change that I'm most excited about with respect to the new repay plan, is that it's actually going to halt unpaid interest accumulation for any period of time that the borrower is in the plan. So right now, a borrower who is in a $0 a month income-driven repayment plan will likely see their overall loan balance grow every month, because even though they're good on their payments and in repayment status, interest is still accumulating each month. Under this new repay plan, though, what the government is saying, if you have a $0 monthly payment amount, you're good. You're not only good with respect to your repayment status and avoiding default, but we're also going to waive any interest accumulation so that 5 years down the road, your loan balance isn't going to have ballooned just by virtue of you being in an income-driven repayment plan. Finally, the last big change with respect to the new repay plan that's coming is that borrowers who have a limited amount of debt, so in particular, borrowers who have $12,000 or less of debt, whose initial debt load was $12,000 or less, will actually be able to get forgiveness within 10 years. And so that means for most students who attend a community college, they're going to be eligible for forgiveness within 10 years. For borrowers who have between $13,000 and $19,000 of debt when they of initial loan balance, the department will grant forgiveness 1 year more for each additional $1,000. So, for instance, if a borrower started with $13,000 in undergraduate debt, they can get forgiveness in 11 years of being in repayment. 14,000 would be 12 years, and so forth, up to a maximum of 20 to 25 years depending on whether the borrower also has graduate debt. So again, just a flag, some point later this year, this plan will be coming. And once it does, I think for most borrowers, except those with Parent Plus loans, the advice is going to be get into this repay plan. So how do you actually apply? So I mentioned there's an easy online form where you can do it on the Department of Education's website. And as this shows, you can select the specific plan that you want, or you can check that first box. I request that my loan holder servicer place me on the plan with the lowest monthly payment amount. And again, for most borrowers, that's going to be the best option. For those borrowers who don't have access online, you can also work with the borrower's loan servicer to submit a very similar application on paper. If there is a way to do it online and to work with the borrower to submit online and create an account with federal student aid, that's generally what we recommend, just because it's you get a faster response. But certainly doing it by paper will also accomplish the end goal. So I want to switch now to 2 time-limited programs that exist to borrowers that they should be thinking about right now and should start taking advantage of if they're eligible. And the first is what's called the Fresh Start for defaulted borrowers. Basically, what the Department of Education has said is borrowers who were in default before the pandemic started, we want to give them a fresh start as repayment resumes. We want to say to those borrowers, here's a shot to get back into good standing with your loans, to get the benefits of having your loans in good standing and no longer suffer the consequences of default. And so for borrowers whose loans were in default as of March 13th, 2020, they're eligible for this Fresh Start program, which will give them renewed access to federal student aid again, stop collections, and make them eligible for other federal loans, and will also require the Department of Education to take steps to repair some of the negative credit reporting that had been and that probably still is occurring with respect to those debts. Now, it's actually really simple for a borrower to opt into the Fresh Start program. And there's 2 ways that a borrower can go about doing it, depending on who has their loan. So for borrowers whose loans currently reside with the Department of Education, so they have either a direct loan or a FFEL loan that the Department of Education now owns, that borrower needs to call what's known as the Default Resolution Group. And I put the number on the screen, and it's also available on the Department of Education's website. And all the borrower needs to say when they call this number is literally, I want access to Fresh Start and I want to be placed in an income-driven repayment plan. And just saying those magic words, the Department of Education will then take steps to get the borrower's loans into good standing. They'll no longer be in default. The borrower needs to do this, though, over the next year. The department, it's somewhat of a moving target just because of the uncertainty of exactly when the exact date that repayment will restart. But borrowers will have approximately 1 year from that time to finish getting into Fresh Start. And so if you're working with a borrower who was in default before the pandemic, there's no reason to wait. Get them into Fresh Start right now. Get them into an IDR plan right now. For borrowers whose loans, though, are owned by a commercial entity but are just backed up by the federal government, those borrowers need to call the private entity. And depending on who it is, the contact information is different. But the Department of Education recently released this helpful website that has all of their contact information. And again, the magic words are just, I want to be on Fresh Start, I want to be in an income-driven repayment plan, and the Department and then that private entity will send over the loan to the Department of Education, who will move it into good standing. The other time-limited option for borrowers is what's now being called the IDR, the Income-Driven Repayment Account Adjustment. So IDR has been around for a few decades at this point, and given the length of time that it takes to get to forgiveness, we should actually be seeing thousands of borrowers who are getting their loans forgiven under these IDR plans. But for a whole bunch of complicated reasons related to both the Department of Education and these loan servicers, this hasn't happened. I think a few years ago, I think in 2019, 137 borrowers in total had received forgiveness under an IDR forgiveness plan. And so recognizing this, the Department of Education has said, something has gone seriously wrong here. We're going to look back at borrowers who have been in repayment, and we're going to make sure that time that they were in repayment counts towards their IDR forgiveness. And so this means what the department is going to do is they're going to do this kind of account reset. They're going to look at a borrower's repayment history and say, for any period where that borrower was in a state of repayment, whether they were in an IDR plan or not, they were in active repayment. If they were in a forbearance for over a year, or if they had a cumulative forbearance of over 3 years, then they're going to take any time in that forbearance beyond that limit. For any time spent in a deferment, except for in-school deferments before 2013, the department's going to take all of that time and say, we're going to count this. And for any economic hardship or military deferments since 2013, the department is also going to look at that time. And for all of these buckets, the department is going to say, we're going to reset, we're going to add all of this up to see how long along the path to forgiveness is this borrower actually. And so for a lot of borrowers, what that's going to mean is they're either going to be eligible for IDR forgiveness right now. They're going to be eligible for IDR forgiveness in a few years, or at least a much shorter time period than they would be without this account adjustment. And for public service loan forgiveness, all of this recalculated time is going to count as months that are eligible for PSLF, for borrowers who are working in public service. And so many borrowers may actually become eligible for that 10-year public service loan forgiveness after this IDR account adjustment. Now, for most borrowers, they're not going to actually have to do anything. They're just going to automatically get the benefits of this account adjustment, except for those borrowers who have those FFEL loans that are held by a commercial entity. And those borrowers, in order to get this benefit, have to consolidate their loans by the end of this calendar year to get the benefits of this program. And so if you are working with a borrower who has commercially held FFEL loans, the advice to them is 9 times out of 10, particularly for those who have been in repayment for a long period of time, consolidate your loans into direct loans so that you can get the benefit of this IDR account adjustment. And the way to consolidate is just by applying through the Department of Education. On their website, they have kind of a how-to and the application for doing so. Periods of default, unfortunately, are not going to count towards the IDR account adjustment, except for those borrowers who have been in default during the COVID payment pause. For those borrowers who then enter the Fresh Start program, the Department of Education will count the last 3 years as time that counts towards this IDR account adjustment. So again, kind of zooming out, you have a borrower who's been in repayment for a long period of time. They have a loan that's a federal loan, but not held by the Department of Education. Get them to consolidate so that they get this benefit. They could be eligible for forgiveness if you do. They could be closer to forgiveness. Really important step, and it's time limit. Going to briefly talk on the one-time student loan cancellation program. And, I think we are all kind of sitting and waiting and watching what's happening because as we wait patiently for the Supreme Court to rule on whether the Biden administration can go forward with the one-time cancellation program. Just by way of background, last August, the president announced a cancellation program that would provide between 10 and 20,000 of loan forgiveness for borrowers who earned less than $125,000 a year for a single borrower, or less than $250,000 a year for a couple or a family. It applied to most federal student loans. About 8 million borrowers were going to be automatically eligible for the relief, and the rest of the borrowers had to complete a very simple application form that took less than 5 minutes. In total, about 23 or 24 million borrowers applied for the relief, including at least 1 million here in Ohio. And the Department of Education has already said that about 16 million of those borrowers met the criteria and would be eligible for the loan discharge. We will learn likely in mid to late June whether the department can go forward with that cancellation or not. So, I think come mid to late June, there will undoubtedly be a lot of news coverage on what the Supreme Court does. And so I recommend, just kind of keeping your eye out for that. If the department is able to go through with its cancellation program, get your borrowers, if they are eligible, to apply for cancellation as quickly as possible. The application form takes less than 5 minutes. We have on our website a how-to document if it becomes relevant again on how to apply for cancellation, FAQs on cancellation, and we're keeping that up to date. So if in July this comes to your mind and you want to know what's going on with cancellation, we have that on our student loan webpage on our legal aid website. A few other very quick kind of changes that are also taking place right now, and I'm not going to get too into the nitty-gritty here, just want to flag them for you as things where borrowers potentially have some student loan relief, and in particular where we at Legal Aid take on cases for borrowers in these different buckets. And so if you have a borrower who's eligible for our services, these are the types of things where we can assist borrowers. First is that there are changes to what's called the borrower defense to repayment rule. And this is essentially a rule that allows borrowers who were defrauded by their school but took out federal loans to try and get those loans discharged and to get a refund on any money that they paid to their school. It's super complicated. The rules have changed a whole bunch over the past decade or so. It is if you have a borrower who went to a school where believe the school engaged in some unlawful misconduct, the borrower might have recourse, and talking to a lawyer is likely the way to go, including here at Legal Aid. Borrower might also have options to pursue an action against that school directly. And in particular, note here that the Department of Education is finalizing rules that's going to prohibit schools that receive federal funding from using class action waivers or pre-dispute arbitration clauses, essentially saying that students have to be able to have their day in court. And then also some changes to some loan discharge programs for students who attended schools that closed while the students were attending. Students who have become totally and permanently disabled and so were unable to work or go back to school. And students who were either the victim of identity theft or forgery, or didn't have a high school diploma at the time that a school signed them up for federal student loans. The one I really want to flag here is the total and permanent disability discharge. If you're working with a borrower who has been on Social Security disability for at least 5 years, come July 1st, that borrower is going to be eligible under new regulations for a loan discharge. The Department of Education has said that they're going to try to do those discharges automatically, but the government, the office that's responsible for all of this has really significant funding issues right now. And so it's not clear to me that they're going to actually be able to do this in a timely manner. And so if you have borrowers who have been on SSDI for at least 5 years, July 1st and later, please, either work with them, refer them to an attorney, refer them to legal aid, to potentially apply for a total and permanent disability discharge, to potentially get all of their loans wiped away as a result of their inability to work or go back to school. Also, new public service loan forgiveness regulations to make sure that borrowers who are in public service jobs get the relief that Congress promised them. And it's not listed on here, but there also have been a whole bunch of sub-regulatory changes in the world of bankruptcy. Previously, bankruptcy was a pretty bad option for student loan borrowers. But what the Department of Education and Department of Justice have recently said is, this isn't working, the system's not working like it's supposed to. For a lot of borrowers, particularly low-income borrowers, particularly older borrowers, the Department of Education is going to be much more likely to stipulate to a discharge of a borrower's student loans in the bankruptcy context. So if you have a borrower who has a lot of debt, student loan and otherwise, and might be a candidate for bankruptcy, again, an attorney here at Legal Aid or otherwise might be able to help them get not only their non-student loans discharged, but now also their student loans discharged. So before we kind of turn to any questions that folks have and finish up for the day, just want to highlight some resources that we have for folks in the community, both providers and borrowers themselves, and we're continuing to develop these and update these. The first is we have self-help materials. Right now, there's a set directly for providers to go to, and there are a whole bunch of common scenarios that borrowers may find themselves in. And we provide some general, guidance on those and general information, and also other resources that might be helpful. And we're also developing a similar document that will be borrower facing. And then at this website, at the student loan homepage, we also have some frequently asked questions, a how-to guide on enrolling in income-driven repayment programs, a how-to on obtaining that student loan data, and so forth. And Nat just put that link in the chat box for you. We're also, for providers, going to be doing what we're calling drop-in hours. So the first Thursday at 12 o'clock in July, August, and September. So right about when we think folks are going to be really thinking about repayment, either me or one of my colleagues will jump in on a Zoom at 12 o'clock, first Thursday of these months, and just be there like an office hour style meeting where come have your questions answered, come listen to other folks' questions. We're just here for you as a resource as you're working with folks in the community. For borrowers, and also, providers can this is more borrower focused, but certainly it's a resource for the community more broadly. We have an economic justice information line, which borrowers can call in, not only to ask questions about employment issues and unemployment issues, but also about student loan issues. So for example, if a borrower is confused as to the status of cancellation or confused about when repayments restarting, you can give this number a call, leave a message with their question, and one of us here at Legal Aid will get back to them. And finally, among kind of other things we're doing, we do offer presentations in the community to borrowers directly or to other service providers. If you are interested in any such presentation, student loan or on some of the other issues that we work on, please go ahead and reach out to us at this email here, outreach@lasclev.org. And with that, gonna leave a ton of time, but if folks have any questions, I am happy to answer anything. And also we're always here if you have any down the road. Well, that I will give everyone there's 7 minutes back and invite you all to go be student loan Jedis as everyone returns to repayment, and get borrowers into income-driven repayment programs, get borrowers into Fresh Start, and their loans consolidated into IDR Account Adjustment. Thank you everyone for joining.